Thanks everyone for joining me. Today you're joining us on a very important matter, that is managing your workplace through COVID. I'm just going to share my screen with you, just so you can actually get an idea of the webinar. It's about job eligibility, it's stand down directions, it's about reduction in hours and salaries, stand downs under the Fair Work Act in this uncertain time, of course. Moray and Agnew are a national law firm who specialise in workplace relations, construction and insurance. Our presenter today is Nick Dougal. He's the National Practice Group Leader for Workplace Relations. So this is an area of law that he knows extraordinarily well. Moray and Agnew have offices all around the country, and they come highly recommended by our partners, AB and advice line. Of course, after this session, if you want more information, I can only encourage you to go to the moray.com.au website and ensure that you reach out to experienced people in this uncertain time. And of course, when it comes to employees and their rights and processes under workplace law, this is a hugely complex area. And so on that basis, I'd like to introduce Nick. I'll just stop sharing my screen for a moment. Nick, if you could just come up and say a few words. Thank you for joining us today. We've got a number of people joining us who predominantly business owners and some senior personnel, all obviously eager to learn more about industrial relations. I might just hand over to you. Thank you.
Thank you, Spiro, and welcome everyone. And thank you for joining us for today's presentation on managing your workforce through the COVID-19 pandemic. The COVID-19 pandemic has, of course, had an unprecedented impact on virtually all aspects of our lives. We've got the health component of the pandemic and also the economic component. And perhaps one of the most striking aspects of the economic consequences of the pandemic has been its impact on jobs. We've all seen businesses fall off a cliff since the pandemic and the government restrictions begun. We've seen the lines outside of Centrelink, the job losses, the people losing their livelihoods, and no industry has been left untouched. And the swimming pool and spa and construction industry has not been left untouched either. And it's really created a completely unprecedented need in terms of workforce management. So we're seeing strategies and urgency and measures taken to deal with one's labour force that, going back 2 months from now, would have been completely unheard of. And so really what it's all been about has been, and the question that I've been dealing with for the past 8 weeks with employers from all sizes, of what are my options? What are my options? My revenue has flatlined. What can I do about one of the largest costs of my or most businesses, which is the cost of my workforce? So today we're going to go through some of your options and some of the new laws that have been created around the pandemic, and hopefully give you some more solutions about how to deal with your workplace as this pandemic and its economic consequences continue to develop. So I'm just going to try and share my screen now.
Nick, while you're doing that, I thought it would be important just to raise a couple of questions.
Sure.
That I've put to the participants today. One is, have you applied for JobKeeper for your employees? We've got 57% that have said yes, 21% that have said no, a whopping 36% said they weren't eligible. In addition to that, we have how you're managing your employees during COVID. 86% said they've kept all their employees on. That's an awesome task, guys. Well done. 0% have had to let anyone go, and 13% are simply waiting to make a decision. They've not yet made a decision one way or the other. In relation to workplace laws and their understanding, 33% say they have a good understanding of workplace laws. 60% say they have a reasonable understanding, and 7% say no understanding at all. So thank you guys for sharing that very important insight into, I guess, your workforce and your understanding of workplace laws. And whilst we all can, I guess, understand that we all can gain some knowledge, it's always important to have that information validated by key individual specialists. I'll hand over to you. Thank you, Nick.
Thanks, Spiro. That information's really helpful. What it tells me is that the swimming pool and spa industry is probably one of the is an industry that is being subject to a secondary impact of the COVID-19 pandemic. I would describe the industries that have been hardest hit and had to take more drastic measures than that are industries such as, gyms, hospitality, such as restaurants, and industries that have been completely shut down. So I think what we're seeing with those secondarily affected industries is that the impact perhaps isn't going to be at the start as steep at the start, but we're going to continue to see it come through, probably in the way of forward orders. The engagement of a company to construct a swimming pool is a pretty long tail transaction. So it may well be months and months before the industry begins to see the full impact on the economy and its business. So that's really interesting to know, and that can inform some of the things I focus on my presentation. So as a brief summary of what we're going to run through, I'm going to begin with some comments in relation to occupational health and safety in light of the enhanced risk of running a labour force when this pandemic is on foot. And then we're going to work through some of the industrial issues, such as stand downs that you may have heard are occurring, entering into voluntary variations with your employees about their terms, so you can manage labour costs and continue to employ people. Redundancy situations we're going to speak about. We're then going to talk about JobKeeper. Interesting to hear the take-up of JobKeeper amongst the audience. And then finally, we're going to look at variations to awards. So we'll speak firstly in relation to occupational health and safety. And we've all seen the government restrictions that have been placed on movement and contact between individuals. And obviously that has an impact on the construction industry, including the construction of pools and spas. It would have an impact, for example, on contact with prospective clients, an impact on an office environment and interactions that can occur there, and also an impact on the construction site itself. So there's all sorts of different work sites and environments that need to be assessed in terms of changing risks to health and safety. And it's important to note that the general obligations of an employer through this crisis remain the same, and that is that you are obliged to provide a working environment which is, to the extent reasonably possible and practicable, free of risks to health and safety. And that might mean adequate facilities, giving employees adequate information and instruction, monitoring health and conditions, and ensuring that employees take care of their own health and safety. So what a lot of that is about in the context of COVID-19 is ensuring that you've got the right measures in place, that your employees are being instructed and are abiding by issues around social distancing, things like the availability of hand sanitizer and things like that, and also bearing in mind contact with other surfaces and things to that effect. So all of those general obligations need to be adapted to deal with the drastic health and safety risk which is posed by COVID-19. Now,
Nick,
yeah.
I might just step in here and just encourage everyone that at any time during this presentation, feel free to use your chat box. You can send messages just to the panelists, myself and Nick. You can also send questions or responses to things that you might hear and include everyone so we can all learn and share. So I'd encourage you just to shoot us through any questions when they come up, or if it's something left field, shoot it through. We'll do our best to respond during the presentation during intermittent breaks. Over to you, Nick.
Thank you. And yeah, certainly do encourage you to ask questions. It's not that often that you've got a lawyer encouraging you to ask whatever technical question that you like, but the clock is off. But this is one of those occasions, so please do take advantage. Want to make the presentation as relevant to all of you as possible. And what I might do is at the end of every section, I'll ask Spiro if there's any question that pertains to that subject matter, so we can take questions as we go. So please keep them coming in. So turning back then to the occupational health and safety issues, it's important to have regard to the fact that there's no one-size-fits-all approach because every workplace is different. There's a current order from the government that every worker who can work from home should work from home. Now, obviously, that's not going to be possible for all employees in an industry such as yours. So you've got to take those measures that are necessary for those workers who are required to present for work. And as I mentioned a moment ago, you might have, various different work sites that you need to manage. Employees on the road, selling your products or services, an office environment, or a construction site environment. So each of those work sites needs its own unique consideration of the health and safety risks that exist in the context of the pandemic, and it needs to have proper protocols in place. So your management of the health and safety risk at your worksite associated with the pandemic has got to be reasonably practicable and proportionate. Part of that, just some practical suggestions, is monitoring official advice and communicating about it. The 1.5 metre social distancing, use of sanitizer. Part of that is control measures. That might include personal protective equipment, unique risks at particular work sites, rescheduling what you can to, for example, facilitate working from home where it's possible, and also education and training. So communicating protocols to your employees as to how they're to conduct their duties in the circumstances. And, that communication and official advice and protocols is a two-way street. You need feedback from your employees as well about the practicality of those measures and how they're being implemented. So that's what I wanted to speak to in relation to occupational health and safety. Spiro, do we have any questions on those aspects?
Thanks, Nick. Yes, we've got some really good questions here.
Right.
There's conflicting advice in the marketplace around a whole range of things, PPE and how people should behave. One of the questions is, What are the views on encouraging, whether it be employee or anyone else, face masks and face shields where practicable?
Look, it's certainly, and just probably a preliminary point in that, a lot of your members probably have independent contractors rather than employees. Occupational health and safety responsibilities extend to independent contractors. So just because they're not your employee, it doesn't mean that you're precluded from OH&S obligations. In particular, if you're the site occupier, if you're the person who's controlling that work site. So you've got to bear that in mind.
A number of our members also have pool shops and full-time employees who are also out in the field through service vehicling, servicing swimming pools and the like. So we cover construction, we cover service, and there are ancillary. We've got a couple of people that are on this webinar at the moment who work in aquatic centres. So we cover the whole gamut. So understood about contractors. What about your own employees, both in the pool shop and out in the field and aquatic centres?
Yeah, so that's, and I think that highlights the complexity for your industry. And, you know, Pat, and to add to that, whilst your members might have these multiple different work sites, at the same time, they're not huge employers either. So they're small businesses with a handful of workers at different kinds of sites. So the OH&S issues arising from the pandemic are significant and a pretty heavy burden, I think, for your members. And it goes to the point that you've got to take, it's horses for courses. You know, someone retail, you know, a pool shop is essentially a retail store. And retail stores have been hugely compromised by the pandemic. You know, there's the downturn in business because people don't want to go to a retail store, but there's also how many people can you have at your retail store? What risks are arising for employees in interacting with the public at that store and things to that effect. So the issues are huge. Now, on the issue of face masks, my first reaction is it certainly doesn't hurt. Face masks are beneficial not only for potentially protecting who has a face mask, but also if someone with a face mask happened to have COVID-19, then it poses a safety barrier for other employees at the site as well. So I don't think it's a practice to be discouraged. Is it something that employers necessarily need to supply? I'm not aware that we're at that point. Now, there might be specific health information in the construction industry that warrants consideration, but I don't think it's a mandatory requirement, but it probably doesn't hurt. And certainly if employees would be more comfortable, I don't think it's something that would be discouraged. Very early on in the pandemic, perhaps before it was even nationally called a pandemic, I was fielding some inquiries from employers saying that they wanted to discourage the practice because it was intimidating to other employees. I think we're way past that. I think if people want to use a face mask in a public site, they're entitled to, but I don't think we're quite at the point where it's going to be mandated. We've seen it in other countries. I think parts of Europe and parts of the US are now requiring it in public areas, but I don't think we're there yet in Australia.
I've got another question, Nick, coming through at the moment. It says, what obligations do employees have and what rights do we have as employees if we have persons, employees or people who repeatedly offend or continually do not comply with protocols in place for distancing, sanitising that the employers put in place? Is this sufficient grounds to stand somebody down for whether it be for a period of time or permanently termination?
We'll deal with stand down in a moment, but the concept of stand down, I don't think necessarily applies to what is in essence a disciplinary issue. But certainly I think the requirement to adhere to these kind of guidelines is absolutely in this context what's called a lawful and reasonable direction. Now, under the definition of serious misconduct in the Fair Work regulations, a failure to adhere to a lawful and reasonable direction can constitute serious misconduct that can warrant the immediate termination of an employee. Now, before going straight to that step and dismissing an employee, what I would be minded to do is to communicate to that employee that, you know, there's evidence that they haven't adhered to it to date. To avoid any doubt about it, it's a lawful and reasonable direction, which is absolutely required in the circumstance. And if there's a failure to follow it going forward, the employee is at risk of termination for serious misconduct. I just do not think we are in a climate where you can tolerate employees not adhering to those guidelines, because it poses a risk to everyone else, and also the viability of the business. You know, we've all seen the outbreak at that meatworks site in Victoria over the last couple of days. If you've got employees not adhering to those requirements, that's what your business is at risk at. And not only is that a huge risk to people's health and safety, but it also, you know, if there was an outbreak, your business would have to be shut down. The consequences would be massive. So it's absolutely something that I don't think can be tolerated in this environment. And if employees were flat out refusing to adhere to it, I'd be inclined to move to dismissal.
Thank you, Nick. I'll let you continue.
Thank you. That's probably a good segue to what I was going to speak to next, which is stand down. And the audience has probably seen the utilisation of standing down employees over the last couple of months. You know, the huge amount of pilots and the like that have been stood down from Qantas, or people associated with sporting industries like the NRL or the AFL. A lot of those businesses have been standing down their workforces. So stand down as a general concept was almost kind of an unheard of power before the COVID-19 pandemic. And what it is at law is that under the Fair Work Act, which is the piece of legislation that applies to all Australian workers, there's a provision that provides for the standing down of an employee where they, quote, cannot be usefully employed due to, quote, a stoppage of work for any cause for which the employer cannot be held responsible. And what we mean when we're talking about a stand down is the employment relationship remains on foot, but that employee is relieved of any work duties or the need to attend for work, and they're not paid. So they're required to go on a period of unpaid leave. So a big question and debate that's been occurring in the labour market is when can an employee stand down their workers? Some of the guidance that the Fair Work Ombudsman have given on this is that you can't stand down a worker just because of a deterioration of business conditions, or because the worker has coronavirus, which would be, you know, cause to take personal leave. So just because your business is suffering doesn't necessarily mean you've got a right to stand down. Where you might have the ability to stand down, however, is where there's been a government direction which essentially requires your business to close. For example, if you operated a gym or a pub, and you just had to close your doors completely to follow that government order, you could stand down your employees in those circumstances. It can also be for other circumstances, and I should say on that point that construction is an industry that has not been ordered to close by the government. It seemed we were getting close to that point in Victoria about 6 weeks ago, but it didn't happen. So construction sites can still operate. So there's not a direct government order, but there can be other consequences because of government orders or international factors that can also warrant a shutdown. For example, a lack of supply. Some businesses might be in circumstances where they just cannot get their tools of the trade. For example, imported goods and things like that. If your business cannot operate, for example, you can't construct pools because you don't have the equipment that you need because of the pandemic, that might be grounds to shut down. Or it might be trading inconsistent with government guidelines. For example, some retail operations have shut down due to their retail sites being inconsistent with social distancing guidelines. That might be a basis to shut down or stand down some of your workers. And I'll say as well that to stand down some workers doesn't necessarily mean that you need to shut down your operations as a whole. For example, you could shut down and cease and stand down employees associated with a retail component of a business, or if you were operating an aquatic centre, for example, and that had to be shut down, you might stand down workers associated with that, but maintain the employment of other employees. So these things are possible. Stand down, the right to stand down workers is something that's now being challenged. In particular, there's a number of test cases going to the Fair Work Commission about the right to stand down in the education sector. So it's not something that employers can take as a carte blanche. So it does need some careful legal advice and things to that effect if that's a measure that you want to take. Before we move on, Spiro, any questions from the audience in relation to stand down?
No, I am getting a question in relation to when they, how does one go about properly documenting a stand down? Because whilst you may have the power and you may reasonably provide a direction under law to somebody to do something, the consistency of them not doing it or not performing under the circumstances may require for them to be terminated, but process and documentation is critical to demonstrating you followed a process. Did you want to speak on that?
Yeah, so if we're talking about executing a stand down, from a procedural perspective, there's not as prescriptive a process as, say, a dismissal or a JobKeeper enabled direction, which we'll go into. The main thing to do when you're standing down an employee is making sure that the grounds fall within the provision. If it's under the Fair Work Act, and there can be other bases or requirements in standing down a worker, for example, if they're covered by an award, but if it's under the Fair Work Act, you've got to be able to factually demonstrate that the employee is being stood down because they cannot be usefully employed due to a stoppage of work. The main thing that we've been advising clients is make that very clear in the letter advising the employee of the stand down, how it's within 5241. Some other things that you've got to take into account is making sure that you've explored all other measures. For example, if the employee can be redeployed elsewhere within your business, you've got to demonstrate that you've endeavoured to do that. Otherwise, you've just got to be clear also when you anticipate the stand down will cease. I think they're the main procedural things that you've got to be clear about with a stand down under the Fair Work Act. And we'll speak a little bit more about the process and procedures if you're covered by JobKeeper. So moving on now to workforce management. So outside of standing down employees, there's been a whole range of measures that employers have been taking at a workforce level or enterprise level to manage labour costs and need through the COVID-19 pandemic. And some of the changes to existing conditions that employers have been implementing have been asking employees who are underutilised to use their annual leave, changing their hours of work, for example, reducing an employee's hours of work from full-time to part-time, changing remuneration. A lot of workforces have asked their employees to take temporary pay cuts. You know, we've seen a lot in the realm of 30% or 20%. So all of these measures are being proposed in a number of workplaces, and we've certainly been involved in a number of those in the construction industry. Now, where you are absent JobKeeper, which we'll speak to, where you are seeking to make those changes, it's important to remember that those kinds of variations to employment can only occur by consent. So your messaging has got to be really spot on if you're asking your workforce to agree to those changes. And a lot of the messaging that we've been involved in is employers delivering the messages, look, you know, there's been a big decline in revenue. Our labour costs are unsustainable at the moment. We want to avoid stand downs. We want to avoid redundancies. But if we're going to, you know, we want to keep all of our employees together. But if we're going to do that, we're all going to have to make sacrifices. And so this is what we're asking of you. Another part of the messaging that we have found helpful is being open with your employees about what kind of hits to their own income that business owners are taking. You know, simultaneously communicating to your own employees the fact that, you know, either you're taking a 50% hit in your own remuneration or even not drawing any profit at all, and are really just working to keep the business going. If that is the case, you know, that sort of disclosure can be helpful in employees understanding the impact on everyone. And what I've seen, what I've observed in being involved in a number of these is that a lot of employees get it, that they can see the drop off in work, they can see the general impact on the community, they can see the increase in unemployment, and they're grateful to have the direct communication. And often, if they're well primed in that regard, if you're telling them that you're going to try and keep their job, and all they're going to be subject to is a 20% reduction in remuneration, they're actually grateful that that's the extent of it, and that there's a plan for the business to get through it, and they're willing to be a productive employee as much as they can to support the business. So, you know, as unprecedented as it is to ask employees to take these kinds of reductions, we're finding, if it's well executed, that the pushback is nominal, and you actually learn a bit about which employees you want to keep on the bus with you. So if it's well executed, it can be a really effective exercise. Just a couple of other suggestions if you're going to look at such measures, is that a lot of your workforces are going to be covered by awards. Awards have consultation requirements that may need to be adhered to in this instance. A lot of awards now have specific provisions around consultations with workforces in the context of COVID-19. So you can actually ask your employees under a specific award clause to reduce hours. So you've got to have regard to those. And And I go back to the point that, clear communication and messaging for these kinds of changes is absolutely critical. But the uptake, if you do it well, can be quite high, because employees appreciate what might happen otherwise, which is the business might not be one of the businesses that survives, or they might be retrenched, or they might be stood down. So that, even with JobKeeper and all of the measures that requires consensual changes to employees' hours, which are temporary through the pandemic, continue to be a huge part of an employer's armoury in managing their workforce through it. Spiros, any questions in relation to that section?
You've answered a great deal of the question I'm going to raise, but there are some aspects that you might like to expand upon.
Yeah, it's a good thing to talk through.
We have a member who's got less than 7 staff, and they say they've got a full-time member on workers' comp because of the downturn now in the future, and obviously due to the reduced, capacity over the summer period. The business was also impacted by bushfires, so they've really copped it quite hard. They'd like to revise their employment for this particular individual to a casual. Obviously, they want to hang on to him, but the circumstances have changed, and they want to know that the fact that he's on compensation, the fact that their business has been decimated by fire and now having to deal with the pandemic, whilst he's on compensation, are they in the position to manage, a pathway towards putting him through to casual whilst adhering to the employment laws?
Yeah, so terminate. So really, if you're converting an employment to casual, you're terminating their permanent employment. So it's not conversion to. So casual employment is employment on a shift-by-shift basis. There's no ongoing obligations to rehire at the end of any shift. So conversion to casual is really what you are, is you're terminating the permanent employment, and that's what you have to justify. Now, the challenge for an employee who's on workers' compensation is there's a significant constriction in the right to terminate an employee in receipt of those compensation payments. And if you terminate for a reason which is not permissible under accident compensation legislation, you can be prosecuted by WorkSafe. So it is, however, possible to make an employee in receipt of workers' compensation payments redundant. So I think that's what you would be looking at. You would need to carefully analyse the context. So that would need to be the subject of specific legal advice. And you would also need to carefully coordinate with your work cover insurer. Now, after a retrenchment of an employee on workers' compensation, they're still going to be in receipt of workers' compensation benefits. So that's something that needs to be managed as well. So it's possible, but it needs to be handled carefully. And certainly it sounds like there's a good context and justification for the redundancy, given the dual impacts of COVID-19 and also businesses that have been affected by bushfire. Spiro, any other questions on that?
No, Nick, over to you.
Excellent. So we'll briefly touch on awards. I'm becoming conscious of time. So as I've said, a lot of awards have changed and have specific measures around COVID-19. Now, award coverage is another interesting issue for your members, and it may well be that they're covered by a number of different awards. For example, admin or office employees might be covered by the Clerk's Award. Employees on site constructing pools might be covered by a General Construction Award, and employees in retail sectors might be covered by a Retail Award, and employees at aquatic sites might be covered by a Sporting Award. So award assessment in your industry is not necessarily an easy exercise, so that requires its own consideration. And after that's been determined, you've got to look at which awards have been updated specifically to the COVID-19 pandemic. Some of the measures that are in a number of awards is that you can, by written agreement, agree with an employee to take annual leave, including double the amount of time on half pay. You can require an employee to take what's called pandemic leave, which is like a form of stand down if they're required to self-isolate. But as I've pointed out, not all awards are covered, so the construction award wouldn't necessarily be covered by that. So you've just got to look at what awards cover your organisation. So looking now at JobKeeper, you would have heard of the JobKeeper provisions. The key elements of that is that employers have got to be eligible, and to be eligible, in general terms, they need to demonstrate that they've suffered a 30% downturn in revenue compared to the same time last year. There's all kinds of different combinations and permutations around that. For example, if a business wasn't operating 12 months ago, if it's a growth business with higher costs, or if you've got a lag in that reduction in revenue. But there's detailed guidelines from Treasury about eligibility, and I'm certainly working with a number of employers who are trying to squeeze themselves in on different various reasons. Likewise, you can also work with your accountant in that respect. If you are eligible for work, JobKeeper, the key aspect of the provision is that you get a subsidy towards your employees' wages of $1,500 gross every fortnight. And that can be payable for employees who are still working with you, employees who you have stood down, or you can even rehire recently retrenched employees in order to give them that subsidy. And it's also available to your long-term casuals. So the idea is that the employer gets a subsidy towards their wages of their employees who are still working. And for those employees who have been stood down or otherwise impacted, they get something of a stipend, which continues to be processed as a wage. And rather than the employee employment ceasing and the employee accessing JobSeeker, there's a sort of a bridge that is kept in the employment to hopefully keep that employee in employment and then resume normal employment after the pandemic abates. So once an employee, and I should say there's all sorts of procedural steps that needs to be taken to access JobKeeper. You've got to apply, and you've got to give your employees nomination forms and things like that. And there's all sorts of very technical and different issues that are coming out of access to JobKeeper. For example, the whole $1,500 has got to be passed on to the employee, which means that for some part-time employees, they're effectively getting a pay rise, and all sorts of questions like that. Now, once an employee is on JobKeeper, there can be, or an employer, I should say, is eligible, there can be a whole range of new specific, what's called JobKeeper-enabled directions that employer can issue. For example, employers have a greater ability to unilaterally make directions in relation to where work is performed, also to stand down employees, to require them to take annual leave and things to that effect. So we spoke before about these kinds of consensual variations. In undertaking JobKeeper-enabled directions, there's a greater capacity to direct your workers to actually adjust their employment conditions in that way. It's still got to be reasonable in the circumstances. There's a requirement to give written notice of 3 days, and there needs to be consultation. But the JobKeeper enabled directions give employers a lot more scope to change the conditions of employment of their employees while the JobKeeper system and subsidy remains in place, which is scheduled to occur into September. So further on the JobKeeper enabled directions, as I say, they operate until the 28th of September. They include standing down employees, where the employee then just gets the JobKeeper subsidy of the $1,500 a fortnight less tax. And there can be other reductions in hours or taking annual leave. If there's a dispute about a JobKeeper enabled direction, that can be taken to the Fair Work Commission. And there's also changes to general protection provisions, which is a specific claim that can be made in employment to cover the workplace rights of workers in relation to JobKeeper enabled directions. Perhaps I'm going to make some final observations now, and then we're just going to leave a little bit of room for final questions and answers. So in terms of my final observations, the main things I think it's critical for employers to do is to monitor the ongoing landscape. This is a rapidly changing environment all the time. Now, hopefully the sorts of changes to the landscape we're monitoring now is an easing of restrictions that might change workplace arrangements for the positive. But I think the other aspect of the landscape that's going to have to be monitored is when is the economic downturn going to peak? It may well be that we're still a while yet in terms of economic conditions continuing to deteriorate. You need to assess measures that you have at your disposal under awards or JobKeeper, and then implement those measures in lines with all procedural requirements. Retain utilisation of other workplace management measures. Just because you've now got JobKeeper doesn't mean that variations by consent aren't going to be the best measure for your business. As I've said, in this current environment, despite the drastic things that are being asked of employees, from a commercial perspective, most employees get it, provided that employers are communicating effectively. The way that legal advice and services are being dispensed to support business has changed dramatically. You know, it's really not an environment for lawyers to tell you how it has to be done, which is draconian and doesn't suit the times. You know, you really need to expect your legal advisors or workplace advisors to adapt to really be able to implement what you want. It's a very fast moving environment that everyone has to be really adaptive to. And the final thing is, you know, continue to stay safe. All of these economic pressures do not preclude your obligation to provide a workplace which is free of risks to health and safety, as we've been speaking about. That's it for the substantive part of the presentation. You'll see my contact details up. So any questions that I can't answer in the context of this, I'm more than happy to continue on the conversation with anyone associated with SPARZA. But Spiro, do we have time for any final questions?
We do. We've got a couple. One is, if a part-time, I think you've already answered it, but if a part-time employee is just doing 1.5 days a week now and they get JobKeeper, is it reasonable, legal, for the employer to compel them to work longer hours?
It's possible. There's provision in the JobKeeper changes in legislations to ask employees to change their hours of work, and that can include increasing hours of work. There's got to be consultation. The refusal can't be unreasonable. So what you've got to try and do is work with your employee to work out when they can do those extra hours that you want to match their hours that they're working and the pay that they're getting to their actual hours. So, you know, a lot of people in part-time work have other commitments, family commitments, things like that. So you've got to try and balance their other needs with the increase in hours that you're asking of them. For example, can you do small increases to their start and finish times to manage it that way? But it is possible, and we're certainly assisting a number of employers do that to make sure that they're making the most of the JobKeeper subsidy.
A couple of, I guess, shorter questions, and that are, does the 30% downturn have to remain at 30% each and every month that the JobKeeper is claimed?
It's a good question. It's important to remember that the JobKeeper, access to the JobKeeper subsidy is a sort of a fortnight by fortnight assessment. So it is possible that changes in revenue can adjust that. My general understanding has been that once you're in, you're in, but I'd need to look at that more specifically.
Okay. One more. We've got two more questions, and we'll then sort of tone the presentation down. If a subcontractor has a business but they're not a company, so they've got an ABN, they're registered for ABN purposes.
Yep.
Do they have any recourse through JobKeeper? So through an employer,
Yep.
So they're engaged by an employer. They're not a subcontractor. They're not a company. They have an ABN.
Yep. So what you're talking about then is a sole trader independent contractor. I'm not aware that they're eligible for JobKeeper from their principal who engages them. I'm not aware that JobKeeper is accessible by independent contractors, but if they've got their own business, they might be able to say that as a business, they're eligible for JobKeeper, but they would then need to demonstrate that the individual who's performing the work is an employee. So that might be more likely if that subcontractor was a services company who then employed the nominated person to perform the services.
Fantastic. Now, one last question, and it's really a question, and you might be able to answer it. Is providing the employee the opportunity to take annual leave counterproductive to assisting the employer manage cash flow and finances when you're in fact paying normal wages?
Yeah, a lot of employers have taken the view no, because, you know, cash is king, and, you know, you might be winding down a liability on your books, but you're letting cash go out the door at a specific time when you might be wanting to hold on to. So a lot of employers have taken the view that that's not a measure which assists right now. And that's why they are looking at either stand downs that we've been speaking about, pay reductions and still getting some productivity, or where they're eligible for JobKeeper enabled directions. So it's certainly not a measure that always works.
That's it for now, Nick. If I can just ask you to stop sharing your page for the moment. Please don't go, people, because I've got something interesting for you. I'm going to share a screen for you, if I might, something that we think that you will find very interesting. One moment. So I want to thank everybody. Nick, can you just confirm, are you seeing my notes there?
I am, yes.
I'll just redo that. Excuse us a moment. Thank you. I just want to thank everybody for coming along. All of you will get a certificate of attendance, as you can see there, sort of moving nicely on the screen, I think. You're also, for SPARSA members, you're going to get CPD points for attending this session. Please register for next week's Business Centre webinar, Intelligence versus Emotional Intelligence. I want to thank Nick for coming along and delivering a very valuable session. Nick is from Moray and Agnew Lawyers. Their details are below. These are very difficult times for all of us. and navigating our way requires really expert advice. Even when we think we have the answers, it's important to ensure that the pathway is signed off by somebody with a little bit more than a little knowledge. So on behalf of Moray and Ague, Nick, from Sparza Australia, thank you to you and your firm for providing your very valuable time. Thank you so much. Anyone that's got any questions, I'd encourage you, post this to write to nick@moray.com.au. His details were on screen earlier. Again, thank you so much for participating in these valuable webinars that Sparza's putting on. Thank you so much.
Thank you.